The second way that, the nursing home gets paid, and probably the most common, is Medicare. Although in order for Medicare to pay, and it only has a limited benefit that could pay up to 100 days, you would be admitted, and I purposely underline admitted, to a hospital for at least 3 consecutive evenings and then discharged to a nursing home. And if that happens, then the Medicare's component would pay. It would pay the first 20 days in full. Days 21 through 100, there's a copay of $171.50 a day. And I don't know where they come up with that 50 cents, but I'm not making that up. I don't ask me. But you're not guaranteed 100 days. You could get up to 100 days, but I don't want to get into it because we got short time this morning. The third way, of course, of 4 ways to pay for the nursing home is to privately pay. And of course, this is what most clients want to avoid, because that's where they're writing a check for 5 figures every month, which leads, of course, to the last way, Medicaid. And how does, one qualify to have Medicaid pay the bill? And the answer is the applicant would have to pass 3 tests. Number 1 of 3, you have to be in the nursing home, medical need to be there, right? Number 2, as an overview, you have to be financially eligible. And then number 3, you have to pass the, what most people have read or heard about, the 5-year look back transfer penalty rule. So, number 1, you have to be in the nursing home, need to be there. Obviously, we can't help you with that. I always, joke, unless, you want me to go to my car and get my golf clubs and, bang you on the head or something, that situation will present itself. So you have to be in the nursing home, medical need to be there. Number 2, to qualify to have Medicaid pay, you have to be financially eligible, which most people know means that you have to be, quote unquote, poor. Well, what's poor? Poor is defined that the applicant could have assets in their name no greater than $15,750. That's it. Now, people often say, my gosh, that's not much. And I go, you're right. And then they say, do they count everything? Answer, yes, with 6 exceptions. So there are 6 things that the applicant can own that do not count against them. They are, real quick, personal effects. So, the ladies' jewelry or the men's watch collection, they're not interested in that. The household items, they're not really interested. Number 2, the applicant could own 1 automobile. So if someone had purchased a brand new Cadillac, $50,000, a few months ago, doesn't count, even though it's worth more than $15,750. 1 automobile. Number 3, the applicant can own a burial plot. And I often say, isn't that nice? They let you keep your burial plot. But, look, you do pay for something, and you're going to get that spot. And it's not for free unless, of course, you're a veteran and you're entitled to a spot at the, Calverton or some such veterans cemetery. Number 4 of 6 things that don't count, which is related to number 3, you can own a prepaid funeral trust, which is, where you go to the family funeral parlor and you prepay what you want. And by the way, you could actually prepay not just for yourself as far as, services, coffin, that kind of stuff. You can prepay for certain other family members, spouse, children, sons-in-laws. So sometimes in a crisis, people will have money that's a barrier between eligibility. It's not nice, but they could prepay for these things. I mean, we're going to need them one day anyway. It's a nice way to spend the money for something that's necessary to get closer to that eligibility. But you can own a prepaid funeral trust. Number 5, and this is where it starts to get tricky. 1 through 4, if you own it, it just simply doesn't count. It's easy, Number 5, this is where it gets a little tricky. And I think Perry actually asked me some questions on this a couple of times. It has to do with qualified retirement accounts. And qualified retirement accounts can be made, and I have to say, and I say that purposefully, can be made not to count against the applicant when applying for Medicaid. So firstly, what are qualified retirement accounts? These are those tax-deferred accounts like an IRA or a 401k or a 403b. When you're working and you're socking away this money tax-free and it's growing in these accounts tax-free. And then it used to be when you turn 70 and a half, but now with the latest tax law changes, now when you turn 72, you have to start taking what the IRS calls the required minimum distribution. And these accounts, which sometimes can be quite significant, can be made not to count against the applicant. So the usual example I use is, someone calls me, mom's going or dad's going into the nursing home. I say, well, what does, mom own? And they tell me, well, Aaron, the only thing mom owns is this retirement account. Many years? Wow, that didn't sound good.
Someone was shot.
Yeah, either someone sneezed or something fell. Bless you if it was a sneeze. And I say, what does mom own? Mom owns this retirement account. I say, how much is it worth? They say $100,000. I go, that's all mom owns? Yeah, mom rents an apartment. She doesn't, everything's long gone. She's got $100,000 in this IRA. I go, okay. Well, if we apply for Medicaid, having not done anything, she's over-resourced. She has more than $15,750. But what Medicaid permits someone to do is to turn that IRA into a regular monthly income stream. So if we were to tell the institution which holds this IRA to start paying mom a regular monthly amount, and this monthly amount works out to, in totality, throughout the year, an amount greater than the minimum distribution that they're required to take according to IRS rules. And this is calculated based on mom's age and a table that Medicaid publishes. Really, sometimes they use the IRS tables. They call this maximizing the IRA. But if mom takes this regular monthly amount and it gets added to her monthly income, that $100,000 IRA will no longer count as an asset to disqualify mom when determining if she's poor or not. Now, let me pause here and tell you that obviously we've now added to mom's regular monthly income. Mom's going into the nursing home. Presumably she gets her Social Security, she gets her pension, and now she gets this regular monthly amount from this IRA that we've now maximized. What happens to this income? Answer: well, if mom is single or a widow, all of that income is expected to go to the nursing home every month, and Medicaid will pick up the difference. Always remember that Medicaid is the payer of last resort. So, all that income is, except for $50, which goes into a personal needs account. The guys get a shave and a haircut, and, ladies get a hairdo done, and, whatever. I mean, sometimes ladies go $50 for a hairdo. I go, well, what do I know? I get like a $10 haircut. I don't know. But that's what it's, that's where their income goes. Now, just to also dovetail onto that, what happens if mom is the unhealthy spouse, but she has a healthy husband that remains in the community? What happens to mom's income? Answer: well, it really depends on what her husband's income is. This brings up the concept of something called the minimum monthly maintenance needs allowance, which is kind of like a monthly income allowance. And the monthly income allowance this year is $3,216 a month. So the example I give to people, mom's going into the nursing home and she has $2,000 a month in income from all sources: Social Security, pension, this maximized IRA. Dad has $2,000 a month in income from his Social Security and pension. Of mom's $2,000, $1,216 can be added to dad's $2,000 to bring him up to that $3,216. Mom, the difference in mom's income now goes to the nursing home every month, and Medicaid will pick up the difference each month. So, what happens to someone's income depends on, whether they're single, whether their spouse remains in the community healthy, and what that healthy spouse's income is. But moving on to the sixth thing that doesn't count when determining if someone is, poor or not. Just to recap, right? So far, personal effects don't count, one car, burial plot, prepaid funeral trust, and then the fifth thing, and I digressed a little bit because it brought up a couple of topics, was the qualified retirement account, but you have to do something with that. But it's important to know because sometimes these accounts can be very significant for some individuals. Could be hundreds of thousands that could be made not to count against them. The last thing that doesn't count against an applicant, although I always warn people this is a trap, is the applicant's primary residence. So the example I give to people is, mom, kids are coming in, mom needs to go into the nursing home. They don't have a choice in the matter. They can't take mom home. She needs round-the-clock skilled care. And I say, well, if we're exploring Medicaid, what does mom own? And the kids tell me, well, Aaron, the only thing mom owns is her house. As a matter of fact, my sister and I, we help pay the bills. It's been in her house for 60 years. It would have broke our heart to make mom leave her home that she's known for most of her life. But she doesn't have anything. The only thing she owns is the house. And I say, well, how much is it worth? And the kids tell me, well, Aaron, funny you should ask. My sister and I, we were kind of contemplating before this happened, maybe, mom downsizing and moving into an apartment. So we had it appraised, and the appraisal came in at $750,000. I go, okay. I go, and that's all she owns? Yeah. And it's been her primary residence? And yeah, it's been her primary residence for 60 years. I go, okay. We can apply for Medicaid, and Medicaid will pay her bills. And the kids go, what? Wait a minute. We just told you our mom owns a house worth $750,000. She's eligible to have Medicaid pay? I go, yeah, she's eligible. We could apply. Medicaid pays. You don't count the house against her. But here's the trap. And this is where I see this often is when a family is overwhelmed. They're at the nursing home. The nursing home says, you don't have to go to the attorney. We'll do the application for you. And they'll do the application for the family, and they'll get mom on Medicaid. And, mom owning the house is not a barrier to her eligibility, because what happens is Medicaid has the right now to put a lien on this house. And obviously every month that Medicaid is paying the nursing home, this lien gets bigger and bigger. I don't know who the collection attorney was. I remember there was someone here. I'm looking at all these. So, they might get employed by some of the nursing homes, like, knock, knock, knock. Hey, kids, it's time to pay the piper. And they sue the estate, and now that house is, available to repay what Medicaid paid for that applicant during their stay in the nursing home. So, again, to qualify for, and I want to emphasize this purposely, chronic Medicaid, the type of Medicaid that pays for the nursing home, right? 3 tests. You have to be in the nursing home, medical need to be there. You have to be poor, 15,750 in assets or less. Everything counts against you, but for the 6 things we just talked about. By the way, the applicant can have equity in the house of up to, believe it or not, this year, $893,000, and that house will not count against them. But always remember, there's that trap that Medicaid will put a lien on that house, and there will be a day of reckoning when mom needs to make her. They'll sue her estate, and they'll, try to recover from the value of the house. On to test 3. Test 3, of course, is the one that most people come in and they've read or heard about, and that's the 5-year look-back transfer penalty rule. And basically what's going on here is when you apply for Medicaid, Medicaid wants to see records for the applicant and the applicant's spouse for the immediately preceding 5 years. Why? Because Medicaid is looking for something. What are they looking for? Medicaid is looking for what they call uncompensated transfers. Of course, you and I would call these in everyday language gifts. Well, why are they looking for gifts? Answer, because they punish people that make gifts within the 5 years. Why do they do that? Answer, well, if they didn't, everyone can get on Medicaid real easy, right? The kids come to me, mom's sick, you know, she's got a lot of stuff. I'd be able to tell them, look, just give it all to you guys. You're getting it anyway. I saw mom's will. Make mom poor, and she's on Medicaid. Medicaid goes, no, time out. If the applicant makes gifts within 5 years, we're going to punish that applicant. Well, what's the punishment? Answer, it's for a period of time. Well, what's that? What's the period of time? It's basically calculated based on the, that is so important. That's not me. You hear that? Thank you. That was someone, I think, who was on a computer and a phone at the same time. That was awful. Whoever did that. Wow.
Yeah,
What was that?
I think that happens if you
Yeah.
turn on.
Yeah, someone was on the camera and on the phone. That was awful. So, you know, now I've lost track. So we're in the nursing home, and they're looking at the 5 years. They're looking to see if someone made gifts, and they punish people that make gifts within the 5 years. How do they calculate what the punishment is? Which is, of course, a period of time that someone is ineligible for Medicaid to pay. So I always dispel a myth with folks. People think that Medicaid takes their money, and I go, Medicaid takes nothing. What Medicaid does, though, is your parent, your loved one, your grandma, they're in the nursing home, and Medicaid says, don't look to us. We're sorry that mom's in the nursing home, and the nursing home is asking for money, but don't look to us for, you know, X amount of time. And that amount of time is calculated really using simple division. And Medicaid will, what they do each year is they break up the state into 7 regions. And each region is given a regional rate, which is supposed to represent the average monthly cost of being in a nursing home in that particular region of New York State. And our Long Island, Nassau, and Suffolk counties, our regional rate this year is $13,407. It's a made-up fictional number. And although it actually didn't change from last year. And by the way, the city is $12,844. What that really means is when mom is applying for Medicaid and they do this audit over the last 5 years, and they're looking at all her bank statements, investment statements, everything in her financial life over the last 5 years or 60 months must be disclosed. If they see a total of 100,000 in gifts over the course of the 5 years, they would divide that by the regional rate, 13,407, and what would happen is the quotient, that's 7.5, that's the number of months Medicaid says, we're sorry your mom's in the nursing home, but for about 8 months, don't look to us. You figure it out. Your mother gave away $100,000. She could have paid the nursing home. She decided to give it to you kids. We're sorry about that, but for 8 months, don't look to us. You figure it out. So of course it ends up that the family has to turn right around and, you know, probably use this money if they haven't already spent it and pay for the nursing home. But month 9, continuing, Medicaid will pay. Now, that, you know, rule exists. I will say that that's a general rule. There are exceptions to the general rule. And real quick, the biggest exception that we take advantage of every day is transfers between spouses. So if there is a healthy spouse that remains in the community, we could tell the healthy spouse everything that's in your ill spouse's name, or joint with you, if we were to transfer everything to the healthy spouse today, next month, September 1, they're eligible for Medicaid, assuming we brought them below the 15,750. And they go, what? Aren't they going to see that in the 5-year look back? And I'm going to go, yeah, they're going to see this. But so long as the only gifts that were made were to the healthy spouse, that's an exception. And obviously what that then, brings up is now the healthy spouse owns everything, the ill spouse is poor, and the following month they're eligible. I say the following month because Medicaid determines eligibility only at the beginning of every month. So, if we were to do it today, in August, the first time mom would look eligible would be September 1, presumably, because we've gotten rid of everything to the healthy husband. Exception 1 to the 5-year look-back transfer penalty rule, transfers between spouses. Of course, that leads to other things, like we immediately have to change the healthy husband's will, because I can guarantee you that old will says everything to my wife. And if, God forbid, the healthy husband visiting the ill spouse in the nursing home gets hit by a bus and it goes right back to the ill spouse in the nursing home, she's no longer eligible for Medicaid. So there's always these little paths and landmines we have to navigate through depending on the circumstances. Second exception to the 5-year look-back transfer penalty rule, and this comes up all the time. Unfortunately, it's more common than I ever could have realized, is transfers to a disabled child. Now, it's only a child, not a grandchild, not a son-in-law, a disabled child. Any asset of the Medicaid applicant can be transferred to this disabled child. And if the applicant is now poor, next month, they're eligible for Medicaid. Now, when I say disabled child, I want to explain what that means briefly. I think when sometimes people say disabled, they get the impression of some, poor, awful soul born with some birth defects or in an institution. Disabled is defined as receiving Social Security disability. I can't tell you how many times I'm talking, with a family. Mom is in the 90s. The kids are 60s, 70s. And someone, one of the kids had a heart attack or something. They were out on disability. They received Social Security disability. Mom, on the verge of going into the nursing home, can transfer all her assets to that one kid who received Social Security disability. Save everything. Next month, Medicaid will pay from that point forward. That's the law. So the two exceptions that we've talked about are anything and everything of the applicant can be transferred to a spouse, to a healthy spouse, to a disabled child. The third exception is more narrow, and it only involves the primary residence. And wow, this time is running out. The third exception is transfers of a primary residence to a caretaker child. What's a caretaker child? This is not a child that, has some kind of nursing certificate or gets some kind of caregiver's degree or whatever. It's a child that has moved into mom or dad's house and has provided help, presumably, to mom or dad, and has made mom and dad's house their primary residence too. And if this child has moved in, has made it their primary residence, and we always advise them to, change. Hey, Perry, change my tax return. File it now from my mom's address, or change driver's license, voter registration, or whatever it may be. The fact is that the primary residence can be transferred to the caretaker child, and even though it would be seen in that 5-year look-back transfer penalty audit, it's not punished. Not punished. Real quick, number 4, the last exception to the 5-year look-back transfer penalty rule is transfers to a sole benefit trust that could benefit any disabled individual under the age of 65. Now, this trust has to be designed in a way that says that those assets would be spent on that disabled individual, and if there is a balance in that trust account when that disabled individual passes, that's going to go to the state. And it has to be designed that way. in order for that transfer to the trust not to punish the applicant who's now going in the nursing home. But I can tell you that if grandma's going into the nursing home and there is a disabled grandchild, and the choice for grandma is spend my money at the nursing home or give it to a trust for my disabled grandchild, I'm going to get the same kind of help whether Medicaid's paying the nursing home or I'm privately paying the nursing home. I'd rather put it in this trust for my grandson who needs help. You know, even though if there's a balance, it may go to the state one day. It becomes academic sometimes. So that's, you know, the 4 exceptions, generally speaking, to the 5-year look-back transfer penalty rule. And I want to make sure that you guys understand how important, and I always tell people this, when people come into the office and they want to do planning, they often have the impression that the most important legal document or tool is going to be, some kind of fancy trust. And as you guys know, of course, there are fancy trusts that can be employed. But the most important legal document in this type of planning is power of attorney with the statutory gifts riders, for obvious reasons, right? If there's a healthy spouse, the healthy spouse could transfer the ill spouse's, I think you guys understand that. Obviously, it's a little bit more difficult to explain to clients, and the volume of those powers of attorney become overwhelming to a lot of folks. But it's probably the most important legal document in this Medicaid arena. And I always also explain to folks that even in a crisis, if all someone has ever done is created a powerful power of attorney with a statutory gifts rider, at a minimum, we can usually put a strategy together to save about half of that applicant's money, even in a crisis. And then sometimes people say, well, how would that be done? And real quick, if mom had $200,000, making it real simple, and son says mom's going into the nursing home, what would be done? What can we do? And I said, well, if you're the power of attorney, son, I would tell you, you got to do 2 things. Transaction 1, mom's going to make a gift to you of $100,000. It's going to be a gift. And the second transaction is going to be a loan to you from mom to you, son. And that loan will be evidenced by a special promissory note. So now mom's in the nursing home, medical need to be there. Mom's poor, right? She had 200,000, but 100,000 gift, 100,000 loan. Now mom's got 0, so she passes that test. When they look back 5 years, they're going to go, aha, wait a minute, we see $100,000 gift. What's the punishment? 100,000 divided by the regional rate, 13,407, the quotient, 7.5, or whatever that works out to. 8 months, we're not paying. And we're going to go, okay, you got us. So for 8 months, mom's in the nursing home and Medicaid isn't paying. That $100,000 loan will be designed to be repaid to mom over this 8-month penalty period. And it'll be designed to be calculated with her other sources of income to, I don't want to get into the technical part of this, but almost pay the total cost of the monthly nursing home bill, so that after the 8-month penalty, month 9, Medicaid continues, and result, child got to keep, half the money. So even in a crisis with the right power of attorney, even just on the verge of entering the nursing home, there are things that can be done to save even half the assets if they had the right legal tool in place.